Hi, this is R.J. Deacon reading the Supreme Court of the United States slip opinion in Tharpe V Sellers. Decided January 8, 2018. Petitioner Keith Tharpe moved to reopen his federal habeas proceedings regarding his claim that the Georgia jury that convicted him of murder included a white jury, Barney Giotti, who was biased against Tharpe because he's black. See Federal Rule of Civil Procedure 60B6. The district court denied the motion on the grounds that, among other things, Tharpe's claim was procedurally defaulted in state court. The district court also noted that Tharpe could not overcome that procedural default because he had failed to produce any clear and convincing evidence contradicting the state court's determination that Giotti's presence on the jury did not prejudice him. See Tharpe v. Warden, decided September 5, 2017. Tharpe sought a Certificate of Appealability, COA. The 11th Court denied his COA application after deciding that jurists of reason could not dispute that the district court's procedural ruling was correct. See Tharpe v. Warden, September 21, 2017. The 11th Circuit's decision, as we read it, was based solely on its conclusion, rooted in the state court's fact-finding, that Tharpe had failed to show prejudice in connection with his procedurally defaulted claim, i.e. that Tharpe failed to demonstrate that Barney Giotti's behavior had substantial and injurious effect or influence in determining the jury's verdict. Our review of the record compels a different conclusion. The state court's prejudice determination rested on its finding that Giotti's vote to impose the death penalty was not based on Tharpe's race. See Tharpe v. Warden, decided December 1st, 2008. And that factual determination is binding on federal courts, including this court, in the absence of clear and convincing evidence to the contrary. See 28 U.S.C. 2254 E1. Here, however, Tharpe produced a sworn affidavit signed by Giotti, indicating Giotti's view that there are two types of black people. One, black folks, and two, niggers. That Tharpe, who wasn't in the quote-unquote good black folks category, in my book should get the electric chair for what he did. That some jurors voted for death because they felt Tharpe should be an example to other black folks who kill black folks. But that wasn't my reason. And that, after studying the Bible, I have wondered if black people even have souls. Giotti's remarkable affidavit, which he never retracted, presents a strong factual basis for the argument that Tharpe's race affected Giotti's vote for a death verdict. At the very least, jurists of reason could debate whether Tharpe has shown by clear and convincing evidence that the state court's factual determination was wrong. The 11th Circuit erred when it concluded otherwise. The question of prejudice, the ground on which the 11th Circuit chose to dispose of Tharpe's application, is not the only question relevant to the broader inquiry whether Tharpe should have received COA. The district court denied Tharpe's Rule 60B motion on several grounds not addressed by the 11th Circuit. We expressed no view of those issues here. In light of the standard for relief from judgment under Rule 60B6, which is available only in quote-unquote extraordinary circumstances, see Gonzalez versus Crosby, Tharpe faces a high bar in showing that jurists of reason could disagree whether the district court abused its discretion in denying his motion. It may be that, at the end of the day, Tharpe should not receive a COA, and review the denial of a COA is certainly not limited to grounds expressly addressed by the court whose decision is under review. But on the unusual facts of this case, the Court of Appeals review should not have rested on the ground that it was, quote-unquote, indisputable among reasonable jurists that Giotti's service on jury duty did not prejudice Tharpe. We therefore grant Tharpe's motion to proceed in forma pauperis. Grant the petition for certiorari, vacate the judgment of the Court of Appeals, and remand the case for further consideration of the question whether Tharpe is entitled to a COA. It is so ordered.